Hey everyone, welcome to another edition of What It Is, where we talk about the ways U.S. immigration laws affect everyone. I'm Michael Ruttle, immigration attorney and founder at Ruttle Law PC in Torrance, California, where we practice immigration law in all 50 states. Today we're going to talk about what is administrative processing. If you or a family member or a loved one have applied for any visa at a consular post recently, then you may encounter a situation where your case is held for what's called administrative processing. It's something authorized under the Immigration and Nationality Act, but it's frustrating. Why? Because the reasons your case is held for administrative processing are not known, and the time frame is unclear in how long it's going to take them to complete it. However, we know that based on our experience, usually a case is held for administrative processing for three reasons. One, it's for what's called further consultation, meaning the paperwork presented at the interview or during the application process wasn't sufficient for the officer to make a decision, so they need to do some investigation on their own. A second possibility is a database hit from your biometrics, whether when they ran your fingerprints or did a face scan, something popped up that requires further security clearance. A third possibility is something popped up on what's called the technology alert list, meaning if you work for a tech company or business that transfers technology, you have to make sure that you don't have a technology transfer that would be considered illegal under export control laws, which would also require a security clearance. So the time frame for this is also frustrating because it's not known. A few years ago, the government State Department website used to take around 60 days. However, they've removed that from their website conveniently, and now there's a system in place where if your case is held for administrative processing, you can't even inquire about your case until more than 180 days have passed. And then once you are able to inquire at that point, you have to wait at least another 30 days before you can expect to hear a response from the government. So it's very frustrating, to say the least. However, there is some good news with administrative processing. One is that we found that cases held for administrative processing are generally what would be considered otherwise approvable, meaning you had a good chance of getting approved, but something along the way interrupted the process where the officer didn't feel comfortable issuing that visa. More good news about administrative processing is that it's considered without prejudice. Legally, that means you get an opportunity to apply again. So if you have questions about whether your case is affected by administrative processing, contact an immigration attorney at Ruttle Law today to see if we can help you. Hopefully you found this information helpful. If you did, hit that like button, click that bell, subscribe to our YouTube channel if you haven't already, and follow us on Facebook to stay up to date on how U.S. immigration laws affect everyone. As for administrative processing, hopefully you have a better understanding of what it is. I'm Michael Ruttle. Keep climbing that mountain.